There is another judgment came during the process of evaluation of a medical law practice. In 2004, finalized and 2005 and thereafter 2009 was a case of very interesting judgment came in a case of Kashmira Kohli, where this patient went to a gynecologist for diagnostic laparoscopy, which was planned by this gynecologist. During the procedure of this diagnostic laparoscopy, doctor found there's a big fibroid in the uterus. Doctor thought, why not remove the uterus? Because otherwise also patient need to go for second surgery in the future. To save the money, time, agony, he consulted the mother of that particular lady because patient was on OT table and removed the uterus of that lady. Post-surgery, patient has filed a complaint against the gynecologist saying that he made her infertile because she was not having any child. And once uterus was removed, she cannot bear a child. And matter has gone up to Honorable Supreme Court. Very famous case of Dr. Manchanda versus Kashmira Kohli. And finally, in this judgment, the question of consent came because consent is a prime thing in medical practice where consent plays a vital role of protecting doctors for their act, because even the general exception of Indian Penal Code under section 80, 81, 82, 92, if you read that, has very categorically said that anything done with the consent of a person in a good faith to save their life is no offense. So consent plays a very vital role, my friends. And that's the reason consent is mandate in every surgical cases or wherever the procedure is done. Now, in this case, this was argued in a court of law. And the question came that if consent was taken only for diagnostic laparoscopy, why without consent uterus was removed? Now here doctor has defended that mother has given consent because patient was under GA and it was necessary to remove. Court said, have you taken the consent for removing a uterus? Doctor said, no, we did just consulted to the mother. Court asked, is it was an emergency surgery? Doctor said, no, it can be done electively also, thereafter also. And then court found that when consent for one thing was taken and second surgery was not emergency surgery, then doctor must have stopped the surgery, given an opportunity to patient to think and decide, and should have gone for second surgery. And here the consent law got settled in this particular judgment. First time ever, while arguing the matter by the counsels and Honorable Supreme Court in respect to the consent followed across the world has been presented to the court. Like European side, the real consent is followed. Real consent means very strict consent, where you need to explain even death on table to the patient while taking a consent. Means every reality, possible reality need to be explained. And the consent which was followed in major countries like USA, Canada, Australia side, which was known as informed consent, was also been presented to the court. Now, informed consent and real consent were well considered by our court in a country, and their observations said, looking to the population, looking to the scenario, environment of a country, informed consent looks to be more probable, and they have narrated that this need to be followed. And observation of this court says that 4 important ingredients must be in any consent form. 1, doctor must explain the complete benefit and the procedure to the patient. Second, Doctor must explain all possible complications. In informed consent, one beautiful thing was that you need not to go to every extreme step to explain the patient. Like DIC is not possible complication. If you don't mention patient went in DIC and died, you can be safeguarded. But whatever the possible complication. Third, alternative is available. If there is an alternative, explain to the patient with their complication and the benefit. And if patient refuses your first advice, then fourth is a refusal consent. Four important indicators been observed in this judgment. One of the beautiful judgments narrated in this country, in Kashmira Kohli, which has settled the law of the consent in this country. And thereafter, multiple judgment came where, if at all consent format has not been observed, matter has gone against the doctor, because it was found in the country, and you being a learner, if you audit the paper of any hospital, find still in a country 80% places in general consent is the format. But now general consent is got no value in this country after this judgment. If at all opponent cites the judgment against your general consent, it will be difficult for you to defend your right. Kashmira Kohli case was another judgment which settled the law of the consent in this country.